which is presenting evidence that he does have a valid Sixth Amendment right. I think it's up to the Commonwealth. There is no immunity order here. There is no suggestion that an immunity order.
Sixth Amendment?
Fifth Amendment.
Fifth Amendment. It sounded
yes, Fifth Amendment and Article 12. But there is no immunity order here, or even a suggestion that one has been sought or will be sought. And given that, I think there's no question that he's a Fifth Amendment right.
Well, Your Honor, the witness has been validly summoned to the court. He has waived, in accordance with the entire procedure on the interstate agreement, to summon a witness from a foreign state. He executed a full waiver. He is scheduled to be here. He now interposes this issue, Your Honor, but that does not mean he doesn't have to come, because to the extent that that is or can be dealt with, he has to be present in order to do that. So that is not a basis to quash the subpoena. He's not raised a valid claim to quash the subpoena. He's executed a full waiver. We've complied with all of the requirements of the process. He needs to be here in response to the subpoena, and then if there is such an assertion, we'll have to deal with it as it comes.
And the Commonwealth may Commonwealth is retaining its option to seek immunity, I assume.
Correct.
Mr. Jackson asked the court to quash a subpoena and for a protective order preventing the Commonwealth from attempting to secure his attendance again in these proceedings on the grounds that he has a Fifth Amendment privilege not to testify. He did testify in the past before a federal grand jury. He has executed a waiver in the Circuit Court of the 15th Judicial Circuit in Florida, in which he freely and voluntarily waived his right to contest the ordering of his attendance and freely and voluntarily agreed to attend the trial in this case. This waiver does require him to appear here. It does not require him to testify if he has a valid Fifth Amendment privilege. He may very well have a valid Fifth Amendment privilege based on the facts set forth in the motion to quash. Testimony before a grand jury is not a waiver of a privilege for purpose of offering testimony at a separate and indeed unrelated trial. But this court is not bound to accept counsel's representation that the witness will refuse to testify on Fifth Amendment grounds, and that's especially true, whereas here he has opted in the past to testify despite exposing himself to prosecution. But in any event, whether that had occurred or not, this court need not accept counsel's representation, but can have a colloquy with the defendant in which he can be asked a question and see whether he in fact asserts his privilege or whether he just, even without doing that, indicates to the court, given the facts here, that he intends to assert it. He must appear in accordance with the subpoena. He must, and his waiver, and at that time the court will make a determination with respect to the validity of his privilege, and the Commonwealth may choose to seek an order of immunity in order to compel his testimony, particularly in light of counsel's indication that he intends to take his Fifth and the bases for doing so set forth here. The motion to quash and for protective order is denied.
Well, can I just briefly be heard? Number one, I have serious questions, number one, as to the validity of the waiver, and I'd like to raise that question at this time. Number one,
I thought before we began, I asked if there was anything you wanted to add to your papers. You chose not to. You dealt with your waiver in the papers. Normally the court hears argument and then makes a ruling and doesn't hear argument post-ruling, but I will allow you to proceed.
I did not realize that the waiver was an issue at the time. And number one, the waiver is seriously an issue. It's not a knowing involuntary waiver. What occurred is, even though he was represented by counsel, and I'd also like to correct something, a statement the court made. When he first appeared before the grand jury in federal court and testified, he was not provided counsel, nor given a right to counsel at that time. It was only the second time that he asked for counsel, and at that time, in October of 2014, he exercised his Fifth Amendment rights and did not testify before the federal grand jury as set forth in the affidavit. But at that time, he was represented by counsel. The Commonwealth then went to, by way of an investigator from Florida, then went to Mr. Jackson and sought that waiver. I suggest to the court that that is a violation of the Sixth Amendment, and because the Commonwealth fully knew that he was represented by counsel at the time, it is clear that the Commonwealth and the federal prosecutor have been working together on this case. So I do question the validity of that waiver. You want to address that on Monday, but I am not in any way agreeing that that waiver is a valid waiver.
Thank you. The motion to quash is denied. We'll take 15 minutes.